Just give him a call.
This is Ask an Attorney, all about Florida law with attorney Joe Pippen. If you have a legal question, call Joe right now. In Tampa, call 813-287-5700. Anywhere else, toll free at 877-943-9673. That's 877-943-9673. The law office is open. And now your host, Joe Pippen.
Hey, good morning. Welcome to Ask an Attorney, all about Florida law. I'm attorney Joe Pippen, practicing attorney. The law office is open. Hey, you have a legal problem, legal concern, something you'd just like to have more information about? I'd be more than glad to try to help you walk through your situation, answer a few questions, maybe give you some little peace of mind. So if you have a legal question or legal problem, 877, toll-free number, no matter where you're listening, 877-943-9673. That's 877-943-9673, and phone lines are open. Your question can be just about any area of the law. It can be about wills, trust, probate, guardianship, power of attorneys, healthcare surrogates. Living wills can be about trust administration, probate administration. Somebody's already died and they're processing what to do with the estate and who gets what and how to deal with assets in the estate. Any of those type of questions would be great. If you have questions about family law, criminal law, real estate law, landlord-tenant law, just about any area of the law, if you have a question, I'd be more than glad to try to help you. If I can't help you and I don't know the answer, hey, I'll quickly tell you that, but have numerous resources that are also available to me to be able to help you with a legal situation or a legal problem. Again, you have a toll-free number, which is 877-943-9673. That's 877-943-9673. And your phone lines are open. Questions come in about all kinds of things. I had a question yesterday where a lady could not find her mom's documents. Wanted to know if I had the originals. Well, we don't generally keep originals. We have electronic copies of everything, and we can, upon request, if it's not a conflict or every client follows privilege, first of all. So if a family member calls me and says, hey, can I have a copy of my mom's or father's documents? The answer is no. Every client follows privilege and protected. If I have the parent's permission, which sometimes I'll take, sometimes the child will come with the parents and I'll take notes in the file that I have permission to freely discuss any matter with the child and release copies of documents to the child, then, I can. I've gotten permission. But generally, you can't. You might have a child that's on the outs with the parents, and they just want to cause trouble, and they want copies of the documents. Well, every client follows privilege, so I cannot release documents. But I do try to be helpful. If they say, well, the parent can't tell me anything, they're incompetent. They've had a stroke. They have Alzheimer's for a couple of years now. We've waited kind of late to call you, but, we need your help to find the documents. Well, if I can help, I will, but usually I'm going to require at that point, anybody can tell me anything, so I require 2 doctor statements that the person's incapacitated, and then I try to decide if I can find some way to help them out. All right, let's go to Aaron calling from Sarasota as our first caller. Hey, Aaron.
Hey, how you doing today?
I'm doing great, and you?
I'm very well, thank you. My question for you is regarding my mother. I'm her only child, and she has no spouse. And at the moment, she's sort of in the early stages of dementia. We have done a very basic power of attorney so that I can start taking care of her bills and things like that.
Okay, we meaning that was prepared by an attorney, or you tried to do this yourself?
We did it. My mother and I did it with a notary here in Sarasota.
Okay.
And it's just a basic, durable power of attorney. I don't know. I mean, you can tell me whether or not that's actually.
Well, I'd have to see the document, but I think I'd have to see the document, but I would say it's generally a mistake trying to do it yourself. The Florida statutes, changed recently, and there's special paragraphs you have to initial to be able to do the Medicaid planning that's necessary, to be able to create a personal service contract, to be able to shift assets around into non-countable categories. And probably that's one of the more important parts of a power of attorney is getting that part of it right, particularly in your case where she has Alzheimer's and if she's in a nursing home and you need to get extra benefits and so forth, that document really needs to have been done correctly.
Okay. Okay. Well, that one actually wasn't the point of my call, but
all right, go ahead.
More information now. If I'm her only child, is it just by default that the state is going to recognize me as her guardian? No.
There's a whole guardianship process you have to go through.
Even though there's really
well, first of all, let me say that if you had a proper power of attorney, you probably wouldn't need a guardianship.
Okay.
Because you would have the powers, if it was properly done and it covered all the areas it needed to cover, you'd have the area to do anything that she could do for her benefit. And one of the purposes of a valid power of attorney is to not have to pay the expensive process of going to the guardianship court.
Okay. Well, good. Well, then I'll get the new power of attorney documents.
Yeah. Does your mother have a will?
No. Have anything. So
she
has a condominium that she owns up in Detroit that we're in the process of selling. So that should sell within the next couple of weeks or so.
Okay. You're selling that using the power of attorney?
Yeah. I mean, she could sign the documents.
Okay.
I mean, nobody's deemed her incompetent yet.
Okay.
So they definitely have deemed her as having dementia. And her temporal comprehension is somewhat lacking, but you can have a generally normal conversation with her. So
well, good. Well, what are you going to do with the proceeds from the sale of the house?
Pardon me?
What are you going to do with the proceeds from the sale of her real estate in Detroit?
So my intention was to just put it in some sort of a certificate of deposit and just pull from it whenever we needed to pay her bills. Or we needed to, she gets a pension from the company she worked for that for right now covers the cost of the assisted living facility that she's in. But she also has roughly about $350,000 in IRAs and various retirement accounts.
Yeah.
So,
well, just make sure she has proper named beneficiaries on all those.
Yeah, presently I am
the
one on all of them. So
okay.
Yeah.
All right, Aaron. Well, hope I helped you.
Yeah, thank you very much.
Thank you.
Appreciate your time today. Bye.
All right, let's go to Dan in Tarpon Springs.
Hi.
Hey.
How you doing?
I'm doing good. And you?
Great. I got a problem. I bought my daughter, her car broke down and the transmission went out. So we went ahead and I co-signed for her car because she's like a ghost. She didn't have much credit, and she was making the payments for 3 or 4 months, and she took off work a little to go to Arkansas with her friend, and I can't get a hold of her. She won't call me back, and I heard from my son that she's staying up there now. She's not making any of the payments, and I'm paying the insurance and the payments and everything. I'm the main signer on the car. Am I able to go up there and go get the car, or what's the law on that? I don't know.
Okay, well, what name is on the title of the auto?
My name is on the name.
And not hers?
No, not hers.
Oh, well,
Nope.
Hey, I think that you just answered your own question. You're the owner on the title. What's nothing to prevent you from going to go get the car? In fact, here's why you should go get the car. If she has an accident driving that car, guess who they're going to sue?
Right. She's on my insurance, and they know she's driving the car, though.
Yeah, but if she has an accident,
yeah.
I mean, from what you've told me, no offense, I don't mean to talk about your daughter, but it doesn't sound like she's very responsible.
No, she was at first.
Yeah.
I mean, she was doing real good, and then she just, I don't know.
But my point is that if she has an accident, and there's a lawsuit, and the damages are more than the insurance.
Oh, yeah.
Guess who they go after? You.
Yeah.
So she's not even being responsible enough to talk to you.
Yeah, she won't even talk to me. No.
Hey, I'd go get the car. That's called tough love.
when I get there, I don't have a key for it, and what do I have to do? Call the police to have her surrender the keys to me, or?
Well, all right. Do you have any ownership papers? Do you have registration papers? Do you have anything?
She has all that in the car. I'm almost positive. I can go through her room. She was living with me, but I haven't found any paperwork yet.
And this is a new car or an old car?
It's only about a year and a half old.
Well, why don't you call the car dealership and see if you can give them enough information for them to make you an extra key?
Okay, that's a good idea. Okay, thank you so much.
That seems like an easier way to go do it than trying to confront her or get the police involved, and that could be all messy. And
yeah, exactly. Okay, I guess I'll just have to fly up there and find her. I know about where she lives. I do know that much information about it. So.
Well, I'm sorry the relationship's not so good right now, but that's not the last chapter in the story, I'm sure, and maybe everything sooner or later will get much better.
Yes, I know. She was doing so good, and then I don't know what happened.
You think drugs or alcohol might be a problem or an issue?
No, it's a guy. She thinks she's in love. She's 22 years old, and I don't know. It's some guy up there that she's with.
Yeah.
And
all right.
She won't answer my calls and nothing. So.
All right, Dan.
Thank you so much.
All right, well, I wish you well.
I will do that.
All right, thanks. Hey, you're listening to Ask an Attorney, all about Florida law. I'm attorney Joe Pippen, practicing attorney. The phone lines are open. You have a toll-free number, which is 877-943-9673. Phone lines are open, 877-943-9673. Hey, we're broadcasting the show today on multiple stations all through Florida on the radio, but we're also on Facebook. So you could go to my Ask an Attorney page. Law offices of Joseph Pippen. There's 3 pages going on right now. My personal page, if you're a Facebook friend. Hey, if you're not, send me an invite. You could also go to Ask an Attorney, broadcasting live there, and also broadcasting live on the law offices of Joseph Pippen. And if you can find us on Facebook, that would be live. You can actually see a little bit of it. We're also streaming on WeBeam TV, www.WeBeam TV, and they have a selection of past shows there too. So there are multiple ways to either watch now, Ask an Attorney, or if you're on one of the 12 stations around Florida that carry the program, no matter how you are watching or listening, you have a toll-free number, which is 877-943-9673, 877-943-9673. And we're going to go to Michael calling from Jacksonville. Hey, Michael.
Mr. Pippen, good morning. How are you?
I'm doing great. Thank you. Thanks for asking.
Mr. Pippen, I'm a student, and I'm trying to resolve something that we've been going over in class. We're told that trial decisions do not result in case law.
Are you in law school?
I'm not. However, I'm about to finish my paralegal training.
Oh, I see.
I'll be finishing in December.
Okay. All right, what's your question now?
We're taught that trial cases decided at the trial level do not result in case law. We're told that the appellate level and higher is considered case law when you have to have a trial case in order to get to the appellate level.
Correct.
So, could you reflect on that?
Well, trial law is based on whatever the statutes in the lower courts, based on whatever the statutes say. And then the cases that have been appealed to the higher levels, they become more of the case law where people look for cases and to determine what the law actually is. Okay. That makes sense to you?
Well, that helps a little bit. It's in our textbooks. It was given to us by teachers, but it still seems like something of a contradiction, because you have to have something at the trial level before something can be appealed.
Well, the trial level operates on the statutes, number one. So if you appeal your case based on a lower court statutory ruling, basically, or some decisions based on higher cases that have been appealed, and you are in a present-day lower court trial situation, the judges there base their cases on, you don't base your cases on all the state cases at the lower level. You base them on cases that have been appealed and the law has been challenged or established, and it gets to the Court of Appeals in either the state or the federal level. And those are the ones that are documented, the ones where laws have been challenged and so forth. And there's a record of those cases to establish what the law really was and how the statutes were interpreted correctly or not, or all on the Court of Appeals cases.
Oh, okay. Okay.
All right.
That clarifies it some. Thank you so much.
All right. Thanks.
All right. Bye-bye.
Phone numbers are 877-943-9673. You have a toll-free number. We're about maybe a little more than a third of the way through the show. If I can help you in any way, all you have to do is to call 877-943-9673. And if I can help you, all you have to do is to dial that number. Let's go to Tim and Brandon.
Good morning, Joe.
Hey, Tim.
Our question is, we're getting ready to buy a car today. My wife and I were both retired. We'd like to know what's the best way to title that car for estate planning.
Well, okay, who's going to be the primary driver?
My wife.
My suggestion would be to put it in her name.
Okay.
The insurance would be, you would list yourself as a driver for insurance purposes, but the ownership should be just in her name. Here's the reason. If you put both names on the title and the car's in an accident, just like one of my first callers here, if you put both names on the title and the car's in an accident, they can sue both of you. If they sue both of you, they can try to get his, hers, and joint assets.
I see what you're saying.
If you have it in one name and she's driving, so you're kind of playing the odds here. If you have it in one name and she's driving, then they can only sue her, and then they can't get to jointly held assets between husband and wife.
Makes sense to us.
So buy it in her name.
All right.
Now, the other question comes up, well, what happens if she dies first?
Yes.
The husband can go get the car put in his name without a probate, because the auto in that circumstance is not really a probate asset.
And you just take the death certificate with you?
Yeah, the Division of Motor Vehicles will transfer that to the husband's name.
Well, that's excellent. We sure appreciate your show. We've listened to it.
Oh, well, glad to help you. If anything else I can do for you, please just call.
All right.
All right.
Thank you.
Thank you. All right, you're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open, and we would love to try to help you. When we help you, we also think we're probably helping a lot of other people that are listening to the show. I mean, a lot of people that just heard that question and answer say, wow, why do my wife and I own a car jointly? That sounds so logical and safer and more asset protection. Why don't we put it in the drivership might be 80-20. One of you drive at 80%, the other drive 20. It might be 51-49. I always play the odds and tell people to put the car in the name of the primary driver. Never own a car jointly. Never put a child's name on the car. Or if a child has to drive as soon as they can make some money and be somewhat responsible, maybe get them an older car and let them have their own insurance. You take a lot of liability. A car is very dangerous, actually. Lawsuit world, you have an accident. You think it's a fender bender sometimes, and these things get really blown up to a big hassle and cost lots of money. Hey, if you have a question, 877-943-9673. That's 877. Phone lines are open, 943-9673. If I can help you in any way, please call. Well, you're listening on multiple stations around Florida. We're broadcasting today from the Tampa area. And if you are listening in Tampa, you're probably listening to one of the stations that I'm going to list here. That's 570, 910, 860, 1380, 930. There's a wide variety of signals that go all over the place in every direction you can think of here, broadcasting from Tampa over to Orlando, down to Pasco, Trinity, Manatee, Sarasota. Just about a big circle there of that part of the state. Also, you're listening on a community station in Sun City Center, a small local community station, great little station. Love being over there on that station as well. You're listening on 90.3 FM out of Haines City, Florida. Big circle there going from Haines City to Orlando to Lakeland, Mulberry, all those locations. You're also listening in Crystal River. In fact, I saw was some activity going on in Crystal River, and I saw the radio truck from that station there on site last night on the news. I'm glad to be there. Actually, I got a speaking engagement from a church up in the Crystal River, Brooksville area, talking to a church member who wanted to have me come up there. I was glad to do it. Looking forward to that soon. I'll announce that pretty soon when we get all that finalized. You're listening in Jacksonville. I've already had a call from Jacksonville on 600 The Answer. And a lot of these stations have small little FM stations that also carry the program. So we're glad to be on all of those. And if you're listening, no matter where, you have a toll-free number. If you're watching on Facebook, if you're listening on the internet, if you're listening to one of those radio stations I just mentioned, you have a toll-free number. Call me if you have a question. I'd love to help you at 877-943-9673. That's 877-943-9673. Let's go to Kurt in St. Petersburg. Hey, Kurt.
Hi, good morning, Mr. Pippen. Thank you for taking my call.
My
wife. I'm sorry.
No, go ahead.
I'm a little nervous.
I'm glad you called, but what can I do for you?
My wife and I own a property in the area, and recently we had to evict a tenant. She developed an alcohol and drug problem, and she wound up assaulting the other resident about 6 weeks ago. And then immediately following that incident, she filed her 60-day notice of intent to move, which would have been September 10th. 2 weeks ago, she refused to pay her last month's rent to August. And so we served her with a 3-day notice.
Mm-hmm.
And she said, okay, well, fine, I'll just leave. She had not paid her last month in advance.
Mm-hmm. And
so she said, okay, fine, I'm not leaving in 3 days. However, I'll be out by the 10th. Like, okay. For the 14th, Monday the 14th. Well, she wound up moving out last weekend, and she caused some damage, maybe altogether between paint and drywall repair and.
Mm-hmm. Do you have a deposit? Security deposit?
Do.
Okay.
We do. Now, does she forfeit that if she breaks her lease?
You need to notify her immediately that you're keeping that and itemize the cost of the damages.
Okay. So she is under the delusion that because she moved out a month early, that she's entitled to her security deposit.
No, she moved out a month early, and you don't have a month in advance, like you said.
She did not.
No, but you're entitled to damages, to repair the damages, but you need to notify her immediately in writing that you're keeping the money and you itemize the expense of all the damage she caused.
Can we apply any of that security deposit to the last month's rent that she owed?
I think you can, but I would add it on. Do the damages exceed the security deposit, though?
Oh, yeah. By about $1,000.
Well, there you go. So
the lost
that
rent.
didn't even become a question. You're keeping all of the money because of the damages on this. The reason for that is damages beyond normal wear and tear. or, other damages. So just itemize them, put a cost factor there, give it to her immediately. Do you know where she went?
She gave a forwarding address of a friend.
Yeah.
We-
Send a
in the
letter and a
past, when
certified
people
letter
have
to
moved-
that address.
Yeah, in the past we've sent letters to the last known address, which was our place, in addition to any place that we thought that, just in case there was any
You can
confusion.
list the background on there, but since the damages exceed the amount of the security deposit, you'll be fine in keeping it, I'm sure.
Now, if you take out the lost rent, it doesn't.
Oh, it doesn't?
Well, if you deducted the lost rent.
Okay. So how much was the security deposit?
The security deposit was $1,800.
And there's a written agreement?
Oh, for the lease?
The lease?
Oh, yeah. Oh, absolutely.
Does it
yeah.
mention the security deposit?
Yes.
And does it have any verbiage after? Is it a larger paragraph that
not
covers what it
under-
covers?
It says it does not, in any form or fashion, cannot be used by the tenant to pay rent. That's not what it was meant to do. Like, somebody just leaves and say, okay, well, you got my security deposit, take it out of there. No, because you may have damaged the place, and so the security deposit is not your last month's rent. Security deposit is security deposit, and then if you pay your last month's rent and then leave, you're in good standing and there's not that much damage, then you get your money back.
All right, so she left the 14th. Is that right?
She was, yes, August 14th.
But she paid no rent for the 14 days.
No, not the 14 days, and she left a month early. She was supposed, by her notice, she was supposed to leave September 10th.
Oh, I see. So you are going to charge her for the month she didn't stay because of the lease, the following month. Yeah.
Is that reasonable?
Well, I would add that to the to your letter, and then if she complains, you can always sue her for the damages in small claims court.
Oh, we're so glad she, between her assaulting another tenant and, we're just glad she's out of here and there was nothing else.
Yeah, add that to the letter of the money owes you. Add all the damages, add the half a month rent and the following month rent per contract. And if she never makes an issue of it, you have the money. If she makes an issue of it, you counter with going back to small claims court for the balance. For the balance.
Okay. Do you need to have somebody represent you in small claims court? We've never been.
Well, if you've never been, I would say the first time you should definitely have someone represent you.
Okay.
And particularly if the other side has somebody.
Yeah, it's too bad we don't have the same last name. Man, you're a good person to talk to.
All right. Well, thank you so much for calling.
Thank you, Mr. Pippen.
All right, thank you.
Have an excellent day.
Well, you too. You're listening to Ask an Attorney, all about Florida law. You might be watching on Facebook. You might be watching on WeBeam TV. But no matter how you're listening or watching us or both, you have a toll-free number, 877-943-9673. That's 877-943-9673. I'm here to help you in any way I possibly can on Ask an Attorney, all about Florida law. If you'd like our free poster sheet, we have a poster sheet on estate planning. And it's like 5 articles on one side of the sheet, all about wills and trusts and your various options and the pluses and minuses and consequences of those. On the other side of the sheet has all of our office locations around Florida with addresses and phone numbers and a list of our attorneys and so forth. If you'd like this, there's 1 of 3 ways you can receive it. You can call our toll-free number, 1-800-226, this is the office number now, 1-800-226-3529. You can email me for it at Joe, at ATTYPIP.com. You can also text for it at 727-667-3637. 3967. All right, let's go to Stephen in Jacksonville. Hey, Stephen.
Hey, good morning, Joe. I got a quick question about making a decision with a grandmother that needs assisted living. One of the options that we have is that a family member, a sister of mine who has some, not an RN, but some basic nursing assistance, they talked about moving in with her. And but the current living situation, they would need more room, so they would have to get a different house. And we were talking about renting a house or possibly buying another one. She's maybe got just enough savings where she can buy a home. She's got a little bit of a retirement, a little bit of monthly income. But I've seen a few things where if she needs some care later that may require Medicaid or something, if we do something like buy a house, we may run into some problems with Medicaid.
No, actually, it's just the opposite. A house is a non-countable exempt asset from determining whether you can qualify for Medicaid.
Oh.
So if she owned...
Just the opposite.
No, a house... You're calling from Jacksonville, so this is a Florida question, right?
She's actually in the state of Maine.
Oh, there you go. Well, in Maine, it might be totally different, and I don't practice in Maine and don't know anything about Maine law.
Right.
But in Florida, the homestead is a non-countable asset. So this house with your sister?
Right.
That would be in Maine or Florida?
It would be in Maine.
Yeah. No, I'm sorry, I can't help you about Maine law.
Okay, but
if you move her to Florida and buy a house, the home is exempt.
Okay.
And that's one of the strategies we use in the Medicaid planning sometimes is to either pay off the mortgage because the house is exempt, use countable cash, like, CDs, cash, and so forth. That's countable. And the house is not. So if you had $100,000 in cash that would disqualify you for Medicaid, and you have a $100,000 mortgage on your house, you pay off the house because the house is non-countable, then you qualify for Medicaid and keep the house and pass it on to heirs. One of the Medicaid strategies in Florida is is having a homestead. And also in Florida, the Medicaid law is a big federal umbrella that states get to pick and choose the parts of it they want for their state.
Okay.
In Florida, you can even have rental homes, and the home itself doesn't count, just the income stream, which you can then convert that to what's called an income trust and still qualify for Medicaid.
Okay.
Lots of planning opportunity. I have a full-time Medicaid attorney. That's all he does.
Okay.
And we help people quite a bit in Florida on qualifying for Medicaid.
Do you see a lot of people move to Florida for that reason?
Some, when there's a choice. When they have family in Florida and the family comes in to discuss Medicaid, and we tell them some of these some things you can have in Florida and still qualify for Medicaid. Yeah,
okay.
we had people move to Florida.
Well, that is one of the possibilities too that we're exploring too. So
we had a client that had no house one time, was in a nursing home, had no house, had money. The amount of money kind of equaled what the son's mortgage was on his house. So actually, we took her money, sold her the house, did a living trust for the mom, which gave the house back to the son when she died. So for a couple of years, she qualified for Medicaid because she had a homestead that was exempt and non-countable, and then the money got left back to the state.
Right.
Some people read listening to this story, and they will say, well, gee, that doesn't sound right. Medicaid's for poor people, and mother should have just paid her own expenses in Medicaid, and she should not have weaseled everything around and turned it into where she qualifies for Medicaid, and the state and taxpayers have to pay for all that, and the son got a house, got his mortgage, and all that doesn't sound right.
Right.
Here's my response to that, because I know people are thinking that. Hey, I am the person that people come to ask for legal advice and what their options are. I'm not suggesting you do this. You ask me what your options are, and I'm just simply explaining them what the options are under Florida law. You make the decision. I'm just the educator, so to speak, and I'll be glad to implement whatever you decide. you asked me what the options are, it'd be I'd have an ethical problem, I think, if I didn't tell you all of your options because you asked me the question. And
Well,
this
that's
is
right.
what the options are, and you're the decision maker. I'm not trying to talk you into anything. You know, here's what the facts are. You decide what the solution, your solution is, and tell me how to proceed.
Yeah, and the fear is, I'm seeing that you can move. We spoke about moving her into assisted living, but once the once the memory situation deteriorates,
Mm-hmm.
the costs almost double, and at that point it would be almost unaffordable, and then then we're sort of forced into a really difficult situation at that point.
Yeah. Well, the other thing is, why use up all of your assets when you paid into the system for so long, and why not get the maximum benefits you can from the system? It's just they're just choices you have to make along the way to move things around so you qualify for Medicaid benefits.
Yeah, that was it, and it was tough to find I was finding a lot of conflicting information on the internet, and of course, that's one of those situations where people never. They go
look for
time and only time.
Look for an elder law attorney in Maine, and call a few. Ask them what percentage of their time they spend in Medicaid elder law, and then just make a decision. Or you have also a choice of moving to Florida.
Okay. That's great advice. I'll start there for sure.
All right. Thanks, Stephen.
Thank you, Joe. Okay.
We have offices in Jacksonville, by the way. We have several, and I just arranged a new office, which I'm really excited about, in the Ponte Vedra area. So looking forward to getting that all up and running. If you have a legal question, we have 12 with 13, 14 minutes left in the show. You have a toll-free number, which is 877-943-9673. Phone lines are open, 877-943-9673. If there's anything I can do for you, you have a little bit of time left to call the show, and I would be more than glad to try to help you. I do that all week. I have fun doing it on the radio on weekends. If you'd like to learn more about our law firm, you can go to www.attypip.com. So once in a while, in fact, quite often, we do a living trust for a client who has real estate in multiple states. So I had a client that had a property in New Jersey. So I'm saying, okay, well, I can put your Florida property at 2 Florida properties. I can create the trust, put the 2 Florida properties in the trust. You need a New Jersey attorney to put your New Jersey property into the trust because I'm not licensed in New Jersey, just like in this last call, I wasn't licensed in Maine. So if the attorney has any questions, give me a call. So the attorney sends me this email that they want a letter, basically, the letter was for me to tell him to put it into the trust, and there wasn't any problem with New Jersey law about deeding the property to my trust concerning taxes and Medicaid and things like that. I said, listen, I did a living trust for a Florida resident. They put their Florida property in the Florida trust. I tell them to get a New Jersey attorney to advise them about the very things you're telling me to advise them on. I can't advise them about the taxes in New Jersey. I can't advise them about the Medicaid rules in New Jersey. That's why I sent them to choose an attorney in New Jersey to tell them the laws in that state and how it affects the trust. As far as I'm concerned, they would put the New Jersey property into the trust to avoid probate. If there are other issues that they have to be concerned about, you tell them what they are relative to that state. I can't advise them about the laws in your state. You're the licensed attorney in that state. You tell them. That was an interesting phone call. Let's go to Duncan in Jacksonville. Duncan?
Yes.
Is that your name?
Duncan, yes.
All right. What can I do for you? How do you spell Duncan? How do you spell Duncan, by the way?
Just common spelling, sir.
What now?
Common spelling of Duncan.
Okay.
Question for you is it legal to carry an automatic knife that's under 4 inches or at 4 inches?
I must tell you I don't know the answer to that.
Okay.
I could Google, if you want to email me, I'll Google, I'll research the statutes under automatic knives and see if I can get you an answer, because I like to know the next time somebody asks me.
Great. What's your email?
Joe, Joe, at attypip.com.
All right, sweet. Thank you. I appreciate it.
All right, no problem.
You have a good one, sir.
You too. Let's go to Colleen in Palm Harbor.
Good morning, Joe.
Hey, Colleen.
I purchased a house last year in August in the Palm Harbor, Florida area for my son. And, of course, went through the title company and real estate. And there is associations, homeowners associations attached to this property. And now I'm getting bills from a separate homeowners association, kind of like a sub-association.
Mm-hmm.
So I called the title company and said, you did not do your due diligence with this. You did not tell me that this property was attached to this sub-association. The fees are minimal, but it's also, their rules and regulations. And basically they said, well, sorry, yes, we looked at it, but we didn't notice that, and sorry.
No, who's telling you this? The title company?
The title company.
Mm-hmm.
So I'm assuming that they have title insurance, and it just seems to me that what you do through a title company is basically making sure that they're giving me clear title and what is attached to that title, and they did not do that correctly.
Well, yeah, you probably need to see a real estate attorney to see what legal action you should take. It also seems like the seller or the seller's agent should have maybe disclosed that as well.
That's what the title company is saying to me, that
Yeah.
they should have known there was a sub-agent. You should go back to the real estate agent.
Well, yeah, but if you can't, they're going to blame.
I hire you.
Yeah, they're going to blame one another. So if you're going to take legal action, you probably name them both in the suit and let them sort it out. The question then becomes an economic question of whether you want to pursue that.
Well, I've requested their homeowners association documents because I don't know, what their bylaws are, what restrictions they're going to give me. And now not only is it a monetary thing, but now my property is attached to laws or bylaws that I never saw, nor did I agree to.
Yeah, if you want to contact me, I have an attorney in mind that I think might be able to help you with this situation.
Okay. I heard your email. I will do that.
All right. Thank you. All right. Let's go to Lee in Tampa. Lee in Tampa.
Yes. I do have property overseas, and it's not in my living trust. My living trust was done maybe 3-4 years ago, and the attorney is no longer in practice. He's older, as I am, and I feel, I'm not sure how many years I have left, but I really am trying to have my things in better order than I feel they are.
Well, good for you with that thinking. That's great thinking to have, is to want to get things in order.
Right, and perhaps the solution to my situation is to make an appointment. I live in Tampa, but I have a condo in Clearwater, another condo in Tallahassee, and property overseas. And it's not that it has a vast amount, but I do have 7 grandchildren, and I'd like to be able to leave what I inherited, which I'm from a school teacher, medium. My parents, I'm an only child, so my parents, I feel, left me well, and I try to keep things in good order, but with my age, I'm not being too good with paperwork.
Well, Lee, I'd be glad to help you.
Well, do you think I should make an appointment with a law firm in Tampa or
Well, it's up to you. I mean, my office is in Largo. We could get what I can do for you in one visit. We also have offices in Sun City Center, if that's closer for you. Largo's
much better.
Yeah.
Could I get that paper you said you had.
Oh, the poster sheet. Yeah, you can request for us to mail it to you, or if you make an appointment, you can come in, and I'll be glad to hand it to you.
I think I'd feel better if I made an appointment and get the poster there.
Okay.
What is your address in Largo?
Well, let me give you the phone number, and then when you make the appointment,
Okay.
they'll give it to you. But it's 1920 East Bay Drive. But the phone number is, just use the 727-586-3306 and go to extension 200.
Thank you very much.
Thank you, Lee.
Yeah, bye.
Let's go to Susan in Tampa.
Hi, can you hear me?
I can.
Yeah, I wanted to know if there is a corporation and there's a secretary, treasurer, and a president, vice president, 2 individuals, and the secretary treasurer signs an agreement to sell property. Wouldn't it need the president's signature as well to be valid?
Depends on the bylaws of the corporation and who has authority to do what, basically.
Oh, okay. I guess we've got to check that out then.
All right.
Okay.
All right.
That's all I needed to know.
All
Thank
right.
you for your time.
Thank
Bye-bye.
you. All right, you're listening to Ask an Attorney, all about Florida law. We might have time for one more call. Phone lines are open right now at 877-943-9673. 877-943-9673. I'm Attorney Joe Pippen. If you'd like to contact us, you go to our website if you want to learn more about us at www.attypip.com. You can, if you want to get the free poster sheet that was just mentioned about estate planning, has a little chart about what your options are, the cost of probate, how trusts work, lots of information about estate planning. If you want to receive that, you get it one of 3 ways. You can call our toll-free number, 1-800-226-3529, 1-800-226-3529. You can email me for it at Joe, J-O-E, at attypip.com. You can actually text me your name and address at 727-667-3967. I was just thinking, I had a wonderful time this week at Honeywell. I often get asked to do speaking engagements, and this week I was in Honeywell, right off of Ulmerton Road in Pinellas County, and they had me come speak. The room was it was a large room just filled with people, I guess during their lunch break. They have like a lunch and learn program, and had a really great time, handed out my poster sheet, gave a presentation, about an hour presentation. Half of it was question and answer, which is always fun. So if you have a group you belong to, and the presentation can be 20 minutes, 30 minutes, an hour, doesn't matter to me. If you have a presentation, I can be helpful and provide some education to your group, be able to come in and answer questions about legal topics. All you have to do is to contact our office. Like I was telling you earlier, I had a call from about a church up in the Crystal River area. I'm glad to do that. And I've spoken all over the state of Florida, and I hardly ever turn. If I'm open on my calendar, it can be there. Jacksonville, Orlando, Sarasota, St. Pete, Tampa, Trinity, wherever. If you need a speaker, and if you would consider me, I would be glad to talk to you about it. You can contact our office, 1-800-226-3529, 1-800-226-3529, extension 200. You can email me at Joe, J-O-E, at attypip.com. You can text me that you're interested at 727-667-3967. Let's go to Barbara. I'm not sure I have time to much. We don't have much time, Barbara. What can I do for you?
Just a quick question. You mentioned that you inherited some coins.
Yeah. Uh-huh.
What was the date? Was it 1964?
1964.
Okay, that's all I
Dimes.
wanted
A
to know.
dime is worth $1 if it's all silver, and a quarter is worth $2.50.
And pennies?
Pennies. I didn't talk about pennies. But,
Okay.
All right. Thanks.
Thank you.
Penny's usually worth a penny. There are some old ancient Indian head. Oh, there's the nickels. That's a different story. We'll talk about those later. All right. Hey, thanks for listening. You have a great weekend. So long.